Welcome and thank you for joining Seyfarth's webinar, Game On, College Athlete Employment Status. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Brett Bartlett. Brett, you may begin.
Thank you very much. Good morning, good afternoon. It's good to be joining you guys today, and I think we have an exciting webinar to present to you and a nice discussion with a roundtable at the end. Game On, college athlete employment status, a super exciting topic. And I'm going to introduce myself in just a moment, but I'd like to start off with our speakers. And going left to right, Allison, would you introduce yourself, please?
Sure, thanks, Brett. I'm Allison Silvera. I'm a partner in our Boston office. I do primarily wage and hour litigation and counseling. But before all of that, I was a Division I athlete myself. I was a rower at the University of Michigan.
Hi, everybody. I'm Lila Wild. I'm a senior associate in our San Francisco office. I also do primarily wage and hour work. And before getting here today, I was a college athlete, soccer player at UC Davis.
Hi, everyone. My name is Rob Fisher. I'm a partner in the Boston office. I have the privilege of representing a lot of colleges and universities, primarily in the traditional labor space, but not only in that space. So you'll be hearing a lot from me today about the labor side of things. I have the privilege of not having been a college athlete, so I think I bring a level of neutrality to the discussion that maybe Allison and Lila don't have.
Thank you. And I'm Brett Bartlett. I'm co-chair of Seyfarth's National Wage and Hour Litigation Practice Group. I sit in Atlanta, and I'm a former college swimmer. And if you go to the next slide, please. So we're here to talk about what has become a lightning rod issue of sorts, especially for anyone who has been or is a college athlete, for their schools and alma maters and for their fans. For me, being a swimmer was a way of life, and I swam in college. From middle school through college, it governed my sleeping, studying, and eating habits, as well as most of my social interactions. It provided me a path to and through college. And looking back, I think it provided me with the discipline and wherewithal that have helped me to succeed on my chosen profession. To think that I might have gotten paid hourly wages and might have had the right to bargain as a collegiate swimmer under the NLRA is nothing short of remarkable to my way of thinking. But I can see the other side of the coin too, pun intended. College athletics make tons of money. Why shouldn't the student athletes who drive the engine of the economy enjoy the monetary rewards of it? Especially if they're going to grind the hours and make the sacrifices that come along with the honor of competing for one school. This is the lightning rod issue that we're here to talk about today. And you see a few of the questions that I think are kind of the burning questions that are on top of everyone's mind. But if you go to the next slide, we'll talk quickly through the agenda. We're going to talk just briefly about how it is that we got here, so providing a brief overview. We're going to talk about revenue sharing for college athletes under House versus NCAA. We're going to talk about the current employment status of college athletes under the FLSA, the Fair Labor Standards Act. We're going to talk about current bargaining rights of college athletes under the NLRA, and then we'll have a fun roundtable towards the tail end of our discussion. So with that, I'll turn it over to Allison.
Thanks, Brett. So next slide, Brooke. I promise we're not going to give everybody a full history lesson, but a lot of the arguments around college athletes not being employees are grounded in the concept of amateurism as a differentiating factor for college sports and professional sports from really any other industries. So we thought it was important to at least start here, including that the concept of amateurism, which appears in the NCAA's very first constitution from 1906, and it predates any of the employment laws that we're going to talk about today. And in fact, I think it predates any wage laws in the United States, in any of the states. And what it does and what it did was create an understanding from the outset of organized collegiate athletics that college athletes would not be paid for those endeavors. In fact, it wasn't until 1948 that colleges and universities could cover the cost of tuition for student athletes, and then 1956 before they were allowed to cover the costs of room and board, books, and other incidentals, which we now know of as scholarships. And then from that point until 2021, it basically stayed static with some exceptions, but not without challenge. And so we want to focus on some of those challenges in the last decade on both the labor front and the employment and entitlement to wages front. So I'm going to turn it over to Rob, and he's going to start with sort of the first challenge in the last decade on the labor front. Next slide.
So I actually think, so the Northwestern case has kind of been put in the background because of the recent efforts to organize the Dartmouth basketball team. And I'll talk about Dartmouth in a few minutes. But the Northwestern decision is the only actual decision by the National Labor Relations Board that deals with college athletes. Dartmouth never got to the board. We'll talk a little bit about what happened at USC. That never got to the board. And I say all that because the current state of the law is reflected in Northwestern, and the board's decision, which is a fascinating one as a labor lawyer for a couple of reasons. But the holding is very simple. We're going to decline to exercise jurisdiction over college athletics, period. And what's unusual about the decision, first off, it's unanimous. So for those of you who don't know, the labor board is made up of 5 members, although currently we only have 2. 5 members, 3 of which are typically the same political party as the president. And this was a decision that came down in 2015. So this would have been under the Obama board and a Democratic majority, but the board unanimously held that we're not going to touch this. And just by way of context, the way this came to the board was an organization calling itself the College Athletes Players Association filed a petition. And the petition was, hey, we want to be the union representing the scholarship football players on Northwestern's football team. And the regional director, which is sort of the first stage of the process, said, yeah, let's hold an election. The decision went to the board, and the board decided that it was not going to exercise jurisdiction over college athletes because it wouldn't effectuate the purposes of the act. And there's a couple of points from the decision that I think are really useful. One is the board thinks it's significant that in the entire history of the act, it has never asserted jurisdiction over college student athletes. And it essentially it offers 2 reasons why that is and why it's going to continue that pattern Northwestern. One, and you'll hear me talk about this generally, but they think college athletics doesn't really fit any existing analytical framework under the act, including the analysis of graduate student workers or resident assistants, things that the board has talked about. And they basically say scholarship players are students who receive a scholarship to play on what has traditionally been viewed as extracurricular activity. And because of that, they basically say, look, this is different. And we're not going to disrupt 80 plus years of jurisprudence from the board and suddenly change direction. Now, they don't actually address the question whether college athletes are in fact employees, but in a footnote, they say it's a question that doesn't have an obvious answer. And again, this is a Democratic board saying this. So if you typically associate the Democratic board as looking for an expansive view of the act, this is the board taking a step back. And then the second thing that the board says in Northwestern is that the problem with allowing organizing on a team-by-team basis is that there would be no stability in labor relations, because at the end of the day, the act is really about creating stability between management and unions. And they note that in the professional athlete world, there are there are league-wide bargaining units, which make a lot of sense. But having a single team organized when these teams are under the oversight of the NCAA as well as the conference makes little sense. And the board views that and thinks it's going to actually create less stability rather than more. And so what the board says in Northwestern back in 2015 is, we're not going to touch this. And so when we get to Dartmouth and USC, I just want to again say that this still is the only case on the subject. It is the only board law on the subject regarding the labor rights, if any, of college athletes, which the answer is the board is not extending the jurisdiction of the act to them.
All right, Brooke, next slide. And then the next slide. Okay, so while the board was considering the Northwestern issue before the National Labor Relations Board, the same issue or a similar issue was percolating in the federal court system, which was whether student athletes were employees under the Fair Labor Standards Act, which entitles employees to minimum wage and overtime compensation for all hours worked. Like the National Labor Relations Act, we just had some language on the screen about who's an employee under the National Labor Relations Act. The Fair Labor Standards Act is not a model of clarity. So it comes down 32 years after the NCAA has sort of founded itself on the concept of amateurism. And under the FLSA, an employee is someone who is employed by an employer, which is a definition the Supreme Court has called the broadest that has ever been included in any one act. To employ someone means to suffer or permit them to work, but work is not defined. And so this lack of clarity has led to a myriad of different tests across different courts and industries for what constitutes work and who is an employee. And there's really no uniformity on this. It's something that's often very case specific. We deal with this all the time in what we do in terms of who's an employee, what is compensable time. And here in this context, there's no industry precedence for this. So this case, Berger versus NCAA, was brought by two women's track and field student athletes from Penn against Penn, the NCAA, and 120 D1 colleges and universities. In 2016, the Seventh Circuit found that those students could not assert a claim for employment status under the FLSA. They could not survive a motion to dismiss. And in reaching that decision, the Seventh Circuit rejected any multi-factor test that any courts had applied when looking at when considering the FLSA. And it started its analysis from the premises that there exists a revered tradition of amateurism in college sports. And Brooke, if you can go to the next slide. The court, so it starts with this premises of amateurism. It looked at the NCAA's rules then that define amateurism, what it means to be a student athlete, and hold them to be essential to the very existence of college athletics. It then looked to sort of the Department of Labor's Field Operations Handbook, which helps interpret the FLSA and how the department gives some guidance as to how the Department of Labor does interpret the language of the FLSA. And in that handbook, there's a suggestion that extracurricular and students who participate in extracurricular and interscholastic athletic activities are exempt from coverage under the FLSA. And ultimately, the Seventh Circuit concludes that athletics is not work. And it says that what it talks about is that although we don't doubt student athletes spend a tremendous amount of time playing for their respective schools, they've done so for over 100 years without any real expectation of earning an income. Simply put, student athletic play is not work, as the term is used on the FLSA. This case, Berger, remains good law in the Seventh Circuit. So, and that's important to keep in mind as we move forward in this presentation. This is the law as we sit here today in the Seventh Circuit. You cannot articulate a claim in the Seventh Circuit for employment status under the FLSA for student athletes. Next slide, Brooke. Shortly after the Berger decision came down, a football player from USC brought the same challenge in a lower court in the Ninth Circuit against the NCAA and the Pac-12. In that case, the football player did not name USC. The Ninth Circuit, so the football player was seeking employment status from by the NCAA and the Pac-12 under the FLSA. The Ninth Circuit, considering the same issue, took a different approach. And what the Ninth Circuit did was apply what's a fairly common test for employment status under the FLSA and other industries, which is a test that's known as an economic realities test. And it looks at the three factors that we have here on the screen: an expectation, do you perform the work with an expectation of compensation? Does the alleged employer have the power to hire and fire? And is there evidence that they're evading the law? The Ninth Circuit upheld the trial court's application of these factors, found that the plaintiff could not assert a claim under the FLSA, again at the motion to dismiss phase, against either the NCAA nor the Pac-12. And importantly, what the Ninth Circuit found was that within the analytical framework established by the Supreme Court, the NCAA and the Pac-12 are regulatory bodies, not employers of student athletes under the FLSA. And Dawson remains good law as we sit here today in the Ninth Circuit. So Berger remains good law in the Seventh Circuit. Dawson remains good law in the Ninth Circuit. And then next slide, Brooke. But the next case we want to talk about is Alston versus NCAA. And this is a Supreme Court case that came down in 2021 and really disrupted the landscape. So back in 2014, while all these other cases were pending, including what was happening at the board in Northwestern, a separate case was filed against the NCAA that challenged the NCAA's compensation limits under the antitrust laws. It's not an employment case. The employment status of college athletes was not at issue in that case. But the question that made its way all the way up to the Supreme Court was whether the NCAA's rules that limited education-related compensation and benefits that schools could offer to college athletes, so for example, postgraduate scholarships, expenses related to studying abroad, internships after an athlete's eligibility had expired, violated antitrust laws. What the Supreme Court did was upheld a trial court order enjoining the NCAA's rules limiting these education-related compensation and benefits. For today's purposes, we just want to highlight two parts of this opinion that are important in this, or could become important in this compensation of college athlete space. First, in the majority opinion, Justice Gorsuch makes clear that the decades-old stray comments about college sports and amateurism made in NCAA versus Board of Regents, quote, were dicta and have no bearing on whether the NCAA's current compensation rules are lawful. And the reason that that's important is those are the same comments that the Berger Court relied heavily on in reaching its decision that athletes could not assert a claim under the FLSA. And then the next slide is Justice Kavanaugh's concurrence. So we have some quotes on the screen from Justice Kavanaugh's concurrence, but basically what he does is tears apart the NCAA's rules around amateurism and compensation of college athletes. Again, he's not looking at the employment status of college athletes, but what is pretty clear from this opinion is that if the question of employment status of college athletes were to reach the Supreme Court, which I think it probably will at some day and in some way, at least Justice Kavanaugh has some strong opinions about it. He's not talking about employment laws, but he's thinking about them. And the way we know that is in part of the opinion, he says things like, all of the restaurants in a region cannot come together to cut cooks' wages on the theories that customers prefer to eat from low-paid cooks. Law firms cannot conspire to cabin lawyers' salaries in the name of providing legal services out of a love of the law. Hospitals cannot agree to cap nurses' income in order to create a purer form of helping the sick. Or movie studios cannot collude to slash benefits to camera crews to kindle a spirit of amateurism in Hollywood. He also raises some of the questions that are now percolating to make clear there's sort of no easy answers to the question of, are college athletes employees? For example, how would paying greater compensation to student athletes impact non-revenue raising sports? Could student athletes in some sports, but not others, receive compensation? So he is thinking about these things, even though the Supreme Court wasn't addressing the FLSA. And now I'm going to turn it over to Lila to talk a little bit about the fallout from the Alston decision.
Thank you. So just 9 days after the Alston decision, so in June 2021, the NCAA announced the suspension of name, image, and likeness rules, sometimes called NIL, which allowed college athletes across the country to capitalize off their reputation for the first time. This vote effectively allowed students from coast to coast to strike endorsement deals, profit off their social media accounts, sell autographs, and otherwise make money from their NIL, potentially directing millions of dollars to college athletes every year. This policy change is one of the most significant changes in the NCAA's 115-year history at that point. Then, shortly after that, in September 2021, the National Labor Relations Board General Counsel at the time, Jennifer Abruzzo, issued a memorandum to all field offices providing updated guidance regarding her position that certain players at academic institutions are statutory employees under the NLRA. Citing the Alston decision, Abruzzo was explicit that her position was that scholarship football players at Northwestern and other similarly situated players at other academic institutions clearly satisfied the definition of employee and are therefore allowed to unionize, seek protection from retaliation if they voice concerns about pay and workplace conditions, and otherwise were treated as given the protections of being an employee. Next slide, please. So at the same time as the NCAA NIL rule change in Abruzzo's memo, the House v. NCAA litigation was underway. So this case is a class action lawsuit that was initiated in 2020 by Arizona State University swimmer Grant House and then University of Oregon basketball player Sedona Prince against the NCAA in major athletic conferences. The plaintiffs in-house contended that the NCAA's restrictions on student athlete compensation, particularly concerning NIL rights and revenue sharing from broadcast deals, violated antitrust laws. In May 2024, the NCAA agreed to settlement of approximately $2.8 billion, permitting member institutions to distribute funds to D1 athletes who had competed since 2016. This settlement introduced a revenue-sharing model allowing schools to allocate a portion of their athletic revenues directly to student athletes. But in September 2024, U.S. District Court Judge Claudia Wilkin expressed concerns about aspects of this settlement, particularly provisions that might limit third-party NIL opportunities for athletes. She requested various revisions to address these issues, temporarily halting the settlement's final approval. There have also been a handful of third-party objections. It seems sometimes it seemed like they were coming in every day. Objections to the settlement from people like other athletes, the Ivy League objected, attorneys for athletes objected, and there were various others. Right now, the settlement is set for a final approval hearing on April 7th. If approved, the new revenue sharing model is expected to commence next academic year, so the 2025-26 academic year, making a significant shift in NCAA policies regarding student athlete compensation. Next slide, please. The settlement, if approved, will permit NCAA D1 institutions to share a portion of their annual revenue with student athletes. Specifically, schools could allocate up to 22% of their annual revenue with a cap of approximately $22 million per institution each year, directly to student athletes. This revenue sharing model is optional, not mandatory, so each institution can decide whether to participate. The distribution of funds among sports programs is determined at the discretion of each individual school. Schools that opt into the settlement can directly pay student athletes, aiming to eliminate the need for third-party collectives. These payments are subject to caps under the settlement terms to ensure fairness and compliance with Title IX. But I think the question becomes, what happens if schools choose not to opt into the settlement? Well, for one, athletes cannot receive direct payments from the school. That means that those athletes would miss out on the financial benefits provided by the settlement. Additionally, schools that do not opt in may continue to rely on third-party collectives to manage athlete compensation. This could lead to inconsistency and possibly conflicts with the new settlement framework. Next slide, please. The settlement has brought a lot of animosity. There's been a lot of noise about it, as I noted before, from various individuals and groups, because it's significant, of course, and it also leaves a lot of questions unanswered. So for example, the big one, employment status, which we're obviously talking about today. The settlement does not resolve questions about employment status. It's not at issue in the case. It only involves antitrust litigation. That said, the plaintiffs in the Johnson case, which Allison will talk about next, may cite to the House settlement in support of employee status, because their argument will be revenue sharing results in payment to the athletes for them playing sport, which they'll say supports their argument for employee status. Another big issue is tax implications for student athletes. Athletes receiving the revenue sharing payments will likely receive a 1099. We're going to assume they're going to be 1099 payments, meaning that this is going to be treated as self-employment income. Another big question is the release. So a key provision in the settlement is a broad waiver of past compensation claims. So essentially, athletes who accept payments are giving up their right to pursue legal action related to the compensation disputes from before the settlement. This has major implications because it closes the door on potentially significant back pay claims. Title IX is a huge factor. Revenue sharing payments must be structured to ensure compliance with Title IX. And that means, of course, probably most of you know that gender equity is mandated in educational programs, including athletics. Schools can't proportionately benefit male athletes at the expense of female athletes. They'll need to carefully design their payment structures to avoid triggering Title IX violations, ensuring equitable treatment and opportunities for all student athletes. The NCAA did issue a Q&A not too long ago to provide guidance to D1 membership on the status of the proposed settlements and its potential impact on the enforcement of D1 bylaws. They're definitely worth a read. They're on the NCAA's website. But in summary, while the House v. NCAA settlement represents a significant shift in college athletics, it also introduces a ton of complex legal, financial, and compliance challenges that schools and athletes must carefully navigate. So I'm going to turn it back over to Allison now to talk about Johnson v. NCAA, which is a case that I think is kind of fundamental to what we're talking about today.
Thanks, Lila. And I do just want to point out there's lots of other aspects of the House settlement, like roster limits and all, that are not part of our discussion today. So we were just focused on the compensation pieces of it in terms of how it plays into this employment question. In terms of Johnson, so the Third Circuit is the only circuit to have considered this question of can student athletes state a claim under the FLSA since Alston has come down. Neither the Seventh Circuit nor the Ninth have had an opportunity to reconsider Berger or Dawson, and maybe not surprisingly, Johnson came down the other way. So in July of 2024, the Third Circuit found for the first time that a college athlete in the Third Circuit can articulate a claim under the FLSA. And I think it's really important, and we can't stress enough, that it does not hold that any athlete is an employee under the FLSA, just that they survive a motion to dismiss and can articulate a claim. And now that case is back in the trial court and in litigation. The decision relies really heavily on Alston, and it creates a new, I talked earlier about the multitude of multi-factor tests that different courts apply to decide what's work and who's an employee. Now we have a new one that the Third Circuit has articulated to determine what constitutes an employee in the world of college athletics. And those 4 factors are up on your screen. The Third Circuit found that in their view, collegiate athletes may be employees under the FLSA when they perform services for another party, necessarily and primarily for the other party's benefit, under that party's control or right of control, and in return for express or implied compensation or other in-kind benefits. So that is right now a test that the Third Circuit has articulated for what could constitute a employee in the Third Circuit under the FLSA. The concurrence in Johnson actually goes into so the majority's opinion doesn't really probe the difference between what's play and what is work. But the concurrence starts to talk a lot about that. And what it talks about most particularly is the need to sort of find, weigh, and balance facts, and recognizes that the answer to these questions will vary widely across many thousands of student athletes, teams, sports, colleges, and universities, including fundamentally that not all play is work and not all money is in fact an economic benefit. It also recognizes that the economic reality test does not work on a collective basis, and that our legislative system is not ready for employment status of college athletes. And we'll talk about this a little bit more, but right now, the way that colleges and universities are set up just is not ready for and does not account for, because it was never meant to account for, college athletes being employees. So, Rob, I think it's back to you.
Next slide, please, Brooke. All right, so this gets us to Dartmouth. And this was a very well publicized effort at unionization of the Dartmouth basketball team. This was, and I'll get into the process, what happened in a minute, but what I think is stark about this is if the Dartmouth decision, and this is a regional director decision, the regional director is someone within the NLRB structure, but not the NLRB. If the Dartmouth basketball team can organize on the theory that the players are employees, then it effectively means student athletes anywhere could unionize under the way in which the regional director approaches it. So this started when SEIU, which was already on campus at Dartmouth, filed a petition with Region 1, which is here in Boston, seeking to unionize the Dartmouth basketball team. Not surprisingly, Dartmouth responded back saying, these aren't employees. Oh, and by the way, Northwestern. The regional director held a hearing and she issued a decision. I know all of you know, I suspect all of you know, Dartmouth's in the Ivy League. The Ivy League does not award athletic scholarships. So there is this, not only is Dartmouth not a power school and a power conference in the traditional sense, these are players who are not awarded a scholarship to play basketball. They were eligible for financial aid like any other student, based upon their personal economic need. So I say all that because the way the regional director analyzed the issue was the way in which the board had analyzed graduate students who are assigned research assistantships or teaching assistantships. And essentially the analysis is as follows. Does the student provide a benefit to the university? Doesn't matter whether the student also gets a benefit, just whether the university gets a benefit. And if yes, do they receive compensation? And in a decision that largely ignores Northwestern, other than to say that that Dartmouth had cited to it, the analysis is as simple as that. And most of the decision turns on the question of compensation. And the regional director, Laura Sachs, concludes that they provide a service, they play basketball, it's beneficial to Dartmouth, and in exchange for compensation. Now, as I said, they don't get athletic scholarships. So you'll be thinking, well, what's the compensation? And what they get, according to the regional director, is they get an early read on the financial aid package, meaning that as part of the admission process, they're told earlier than your average student seeking admission what their financial package would look like to help them make a decision. And that in the course of being at Dartmouth, they get clothing, they get shoes, and they get some free tickets. And based upon that, which she characterizes as, quote, rudimentary compensation, that is enough for them to be employees under the National Labor Relations Act. She then directs an election is held, and the union wins the vote 13-2. And so just to get back to the other cases we're talking about, this isn't what we think of as sort of the big money in sports generally. And there was a lot of evidence in the record regarding, how much money Dartmouth actually receives, whether it's operating at a loss. But all of that doesn't really matter to the regional director. And as to the NIL issue, this is one of my favorite footnotes in the decision, is she notes that no member of the team participates in what she refers to as NIL activities, which I take to mean there wasn't a lot of market for, with all due respect to the Dartmouth basketball players, they weren't marketing their name and their likeness or their image. And some of them didn't even have financial scholarships. And yet there is an election, the union wins. Dartmouth filed what's called a request for review. And essentially that is an appeal to the labor board to say, hey, look at what this regional director did. She didn't follow the law under Northwestern. And she's wrong on the notion that they're employees. And then that's been sitting there for some period of time. And then on December 31, the SEIU withdrew its petition. And and in a public statement about the withdrawal, they recognized that this would be the end of the unionizing effort for the Dartmouth basketball team, but they were going to save the precedent. Now, I just want to say a regional director's decision is not the decision of the board. It's not binding on the board. It's not binding on any other regional director. So I'm not sure what precedent it really is, but that was the logic behind what the SEIU did. And we can talk during the roundtable as to what I think is really going on and why it did that. Next slide, please. And then relatedly, there was an unfair labor practice charge at USC involving the football and basketball players. Now, the charge was brought against the USC, the Pac-12, and the NCAA. And the premise of the charge was that those entities were violating the act by categorizing the students as student athletes and not as employees. So essentially, by virtue of treating them as student athletes, those entities, the Pac-12, USC, and the NCAA, were violating the act by not giving them the full rights as employees under the act. The regional director out of Los Angeles, who, by the way, is now the acting general counsel of the board, that just happened like a day or two ago, decides to issue a complaint alleging that, yes, we think there's a violation of the act. It went to a hearing before an administrative law judge. The ALJ heard evidence over a series of dates. The parties all filed post-hearing briefs explaining why they thought they were right or wrong, or the side was right or wrong, and that was in August. It was sitting in front of the ALJ until this past month, when the union filed a motion to withdraw the underlying charge and put an end to the litigation as a whole. Now, that just the judge issued a show cause order, which effectively said, hey, tell me why I shouldn't allow the union to withdraw the charge and put an end to this. I can't read all of the responses from the docket, but it does look like the respondents, USC, Pac-12, and the NCAA, are opposing that request. So it'll be interesting to see what will happen. There's no decision yet that's been reported, at least on the docket. But either the ALJ will end the case because the union is withdrawing its charge, or she won't, and then she ultimately will issue a decision. And the reason why there's a question mark here is the general counsel. The union brought a charge, but it's the general counsel as effectively the prosecutor who's bringing the complaint and alleging a violation of the act. And so in the usual course, if the union wants to walk away from the case, it in fact ends the case. But the respondents have a right to say, no, we should get a decision on this, given how much time and expense has been already committed to this endeavor. So that's where things stand at USC.
So before we, thank you guys, that was amazing. Before we get into our roundtable, we did have one question come through on the Q&A, and just wanted to pose it to the three of you to see if you have any thoughts. Is Congress doing anything about these issues? Are they attempting to legislate around employment status, protect against these efforts to have student athletes be employees? Do you guys know?
I can answer that. There have been lots of bills filed, lots of efforts. I think that's actually, from what I have read, and my understanding is that is actually the NCAA's hope, is that this is solved with a legislative fix. But there have been, over the last several years, lots of legislation filed. None of it has gotten off the ground. I think there's some hope, given that we now have Republican-controlled House and Senate, that maybe something happens in this term. But as far as I know, nothing, no progress has been made. And I think there are other things that might be more in the forefront of the government's mind right now. So I'm not overly optimistic. From what I understand, others are not either, but there's a lot of effort and lobbying going on for that to happen.
Great, thanks. Let's go to the next slide and get that CLE code before we start our roundtable. So the CLE code is SS0203. That's SS0203. leave it on the screen for just a second in case you didn't hear me. Okay, let's move to our roundtable. In the 20 minutes we have left, we'll have a roundtable to let Allison, Lila, and Rob discuss some of the advanced topics. If you do have your own Q&A, feed that into the computer, and I'll try to take a look and maybe be able to throw it in as well. But just to get things started, Rob, because you were talking about union activity, given where we just ended the legal background of this presentation, can you share your thoughts on why the union's petitioning on behalf of the Dartmouth basketball players and USC football and basketball players withdrew their petitions, and what's next?
Yeah, so neither union is really saying what it's doing, but here's my take of what's happening. So right now we have 2 members appointed to the board, which means there are 3 vacancies that will presumably be filled in the upcoming months. And so at some point we will have a Republican majority on the board. And I'll use the Dartmouth case. I think it's the best example. The union received the initial victory before the regional director, but the issue would otherwise be decided by the NLRB. I mean, obviously it would be a dramatic change in law, and so it's the kind of case the board would actually pick up on a request for review. And so I think the short answer is that the withdrawal reflects that the union doesn't want whatever the board is going to look like once it's at full capacity to actually decide the case. And I'm going to use a bad sports analogy, and as Allison and Lila know from our preparation for this program, I have lots of them. The way I would characterize what happened here is, the legal fight was at halftime. They had a regional director decision, they won the union election, and now the second half was beginning, which was an appeal to the full board. And essentially the union, up at the half, ran off the court, took the ball home, and refused to play any longer. And they want to be able to say, hey, look, we won. And be able to, and that the idea is that the unions can sit on the sidelines for the near term until when they think the board is going to be more favorable to them, and then kind of resurrect these issues. And I'm not guessing that this is what they're doing. This is exactly what happened during Trump 1 with the graduate students. So the Obama board had decided the Columbia University case regarding graduate students who serve as research assistants or teaching assistants and saying they could be employees. All of the graduate student petitions that were pending at the time of the Trump 1 inauguration were withdrawn because the unions did not want the anticipated Trump board to decide the issue. And so, that game of keep away was effective. Again, I'm really good at the bad sports analogies or bad puns. And the strategy worked. That Obama decision remains the law of the land, at least from the board's perspective, on graduate students. And so I think that is the same. We're going to see the same thing.
Thanks, Rob. I think we're going to hand the ball off now to Allison, just trying to keep up with you. Allison, if Johnson stands, it sounds like your view is that the analysis is likely team by team, maybe even individual by individual. And given it's a putative collective action, that might be a good thing for the employers. What do you think universities could be doing right now to determine which side of the line their teams currently fall?
Yeah, and I do think it's team by team, and even athlete by athlete. And first, I just want to say I don't think there's any guarantee the Johnson test stands. It's one circuit's attempt to craft a test, but the concurring opinion sort of points out all of its flaws. I don't think amateurism carries the day in the way that it did in Berger, but I also don't think that Johnson necessarily is going to be the test or the right lens to look at all of this under. Even under Johnson, we believe this is defensible. No court has still ever declared that an athlete is an employee. But that said, for schools that are sort of starting to think about this and think about how their athletic departments would stand up, how their programs would stand up under a test like the Johnson test, I think of two key things that schools could proactively be doing. First, the question that they should be thinking about, in my view, is whether there's an argument that the sport is being performed primarily for the benefit of the university or the student, and kind of relatedly, who provides a service to who. And I think a lot of this is the media focus, right? Like if we listen to the media, it's all about the revenue, and media focuses around this sort of revenue driving sports at large institutions and the financial benefit. We know, if you read anything, you know there's like 8 institutions that are revenue positive, or some very small number that the athletic department actually produces a net revenue positive amount year over year. But even for those institutions, revenue doesn't equate to employees and to employment. Rob and I were actually talking about this sort of leading up to this this webinar. We talk about it a lot, and we were talking about this earlier today in the context of volunteers. You can volunteer for a giant global nonprofit with a lot of revenue, but that doesn't make you their employee. Even beyond revenue, and there's so many non-revenue driving sports, we see athletes arguing that schools benefit from sports in things like alumni engagement, advertising, increasing in admissions applications. There's actually something in the Johnson opinion about the Flutie effect. And it talks about this Hail Mary pass from Doug Flutie in 1984, and that he, after he threw this crazy pass, applications to Boston College over the next 2 years jumped by 30%, and somehow Doug Flutie is credited with that. Fundamentally, I think, though, it's really important for colleges and universities to think about, like, students attend college for a degree that will set them up later in life. Who benefits from that? The student does. There's no question about that. So ultimately, I think athletic departments and coaches should think about how they support not only that benefit, but other benefits from participation in athletics, like the growth of the student as a leader, teaching the value of not only winning on the game or the match, but developing character, and making sure that's part of the messaging of what the mission of the department, and just sort of taking that look internally at that, making sure that's part of what you're doing. This seems like the right time for my favorite statistic of all time, which is that 94% of C-suite women, according to Ernst & Young, played sports. And then there's an article last week in Business Insider about how venture capital firms seek out college athletes because of drive and leadership. All of that can be argued to be benefits to student athletes. So colleges and universities should be thinking about this question of benefit and services in something other than revenue, and how they can make those arguments and what they provide other than revenue. And then second is take a hard look at where you fall on the line of control. I think no matter what the test is, the question of control is going to be part of that test. And one of the things that universities and colleges can be doing now is auditing themselves. Obviously, there's guidelines. The NCAA has guidelines and bylaws, and to create sort of fair competition. Those vary sport to sport. But some things to consider is sort of what you do. Is it necessary? Are there places you could pull back in sort of some of those rules of how you run the department? Again, this will vary university to university, sport to sport. One thing I saw recently was this risk factor scorecard that was developed by the D1, AAA, and FCS athletic directors. And it rated different things from green to red in terms of level of control over academic requirements, performance of tasks, mandatory time commitments, from low risk to high risk in terms of how much control programs exert. And for some examples, providing academic advising, squarely in the green, they thought. Low risk, but telling athletes they could not elect certain majors because they were overly time consuming, they put that in the red. Having rules that provide for the safety of athletes while traveling on the road was in the green. That was okay. But prohibiting athletes from seeing members of their family while they were on the road, that was in the red. So just starting to take a look at some of your practices, policies, procedures, rules that you have, and think about them from the perspective of benefits and services and the perspective of control could help make sure you're setting yourself up that if you are pushed, you can fit yourself in and make strong arguments to defend against any claim, no matter what the test is that comes down in the future.
Thanks, Allison. And Johnson makes me think about how the plaintiff's attorneys in that case must have been jumping for joy when they got the win at the Third Circuit. But it just reminds me, again, to the point that you made, all they won was the ability to jump into the pool off the starting blocks. They're going to do the wrong strokes once they're in the water.
Right.
Sorry, Rob, I'm still following your example here. But all that really happened there is that they got past the motion to dismiss. And as a big case litigator, I know, we all know here, that it's really hard to win a case entirely on a motion to dismiss. And so that's all that's happened so far, I think. So let me get to Lila. Lila, building on what Allison was just talking about, are universities starting to actually voluntarily move towards an employment model at this stage for their student athletes?
Yeah, it's a good question. There's definitely a lot of talk about it. But so far, we haven't seen any university that has actually moved in that direction. I think the House settlement has a lot of schools and likely the NCAA and conferences hoping that some of the public pressure will come off with athletes having an ability to share in some of the revenues generated by their participation in sports. But realistically, the rest of our government is not ready at this stage to treat athletes as employees. I mean, the entire athletic scholarship system would need to be revamped, at least for those athletes who would become employees. And there are still a lot of open legislative questions that are raised in the Johnson concurrence, like how that income would be taxed, that need to be guided. There's also, and this is a big one, there's also no currently any overtime exemption under federal law that would likely cover college athletes. So what constitutes an hour of work would need to be carefully navigated. I would also imagine immigration status is another wrinkle that needs to be figured out pretty quickly. I'm not an immigration attorney, but I'm sure that a student visa, but I'm not sure that a student visa would permit a college athlete to be an employee at the university. And I know this has been a struggle in the NIL space.
Right. And Rob, what about on the labor front? Kind of the same line of questions. I know you said earlier that the changes at the NLRB, those changes, the unions have withdrawn their petitions to unionize college athletes, perhaps to wait it out until they have what they view as a more favorable board again. Are you hearing that those efforts are still continuing at the student level? Are they still trying to unionize? And if so, how are universities reacting and what do you recommend?
So I'm not aware of any new efforts by student athletes to organize, whether with a union or without a union. I think the unions are going to stay the course and stay outside of this for a while. The question, I think, is whether or not these issues get to a Trump board a different way. And there's nothing that requires, first of all, that students be affiliated with an established union. And in the higher ed context, we've seen organizing among students that's not student athletes, where they have no affiliation with a union. They're just the university coalition of, I'll say, resident assistants, just some, I'll just use a generic label, where they're just trying to organize and they're saying they're a labor union. So you could see that. And, there's still, I think, a fair amount of pressure on campus for students to organize one way or the other. So I think you might see some of that. The other place you might see it is, depending on how aggressive a university or college wants to be, there are ways in which they could get the issue to a Trump board, to actually have the Trump board say, well, we meant what we said in Northwestern, and we're going to take one step further and say they're not employees. Universities are bargaining with student unions in other contexts. Depending on how aggressive they're willing to be, they could bring unfair labor practice charges. They could deliberately refuse to bargain or take other steps to sort of bait a student union into filing a charge, and to sort of bring this concept of, can students generically be employees under the act? And if so, under what circumstances? And that's going to be broader than, I think, college athletics, but those issues are percolating in the background.
Great. So I'll just note that we're getting a lot of really good questions in the Q&A, and we won't be able to get to all of them, but I think that this next question kind of touches on some of that subject matter. Alice and Lila touched on this a little bit too, but I know one of the concerns with an employment model is cost. For schools that already provide scholarships, arguably an express or implied compensation or in-kind benefit of sorts under Johnson, could scholarships cover wages to make liability essentially a net zero?
Yeah, that's a great question. So I want to start by, For schools that don't currently offer scholarships, I actually think you're in a great position under Johnson, because that the test is conjunctive. That word is and between those prongs. And prong 4, of course, there are arguments about in-kind benefits, but I think it's a real uphill battle for a plaintiff to claim that they had an expectation of compensation or benefits from a school that does not offer scholarships. And the same is made for same case can be made for walk-on athletes, which is why I say this is truly an athlete by athlete test. I know what Rob said earlier about Dartmouth and how the Dartmouth, the regional director got there. I really think it's an uphill battle. For schools that do offer scholarships, at the moment, I don't think there's any real answer to this, but I really hope that we can get to a place where the answer is yes. I know there's a lot of talk about about the cost of an employment model. I firmly believe there's a way to make that work without jeopardizing the future of non-revenue driving sports. As it currently stands, the FLSA allows an employer under certain circumstances to count as wages the cost of things like furnishing to an employee board and lodging and other facilities. So we can envision at least the portion of scholarships that cover board and lodging would count towards wages owed. But we'd need sort of further legislative changes to permit scholarships to cover tuition, so that, for example, hours of work could be tracked and wages earned, but maybe first paid to cover everything a scholarship covers, and then the remainder paid to an athlete. But the problem, I think, with that at the moment is the FLSA also requires an employee to be paid at least minimum wage. So legislative changes would be necessary to permit this. And it really, I think it's possible. I think it may be stomachable, but I think it can't happen right now in the way the FLSA is currently written. And we have to contend with state laws too, which have different requirements for what is minimum wage and how employees have to get paid and what can be counted for what. So it's complicated, but I do think we could get to a place where it's net even for schools that offer scholarships in terms of what athletes that are on scholarships would have to be paid, even if they have to be paid as employees. I also think, though, that one thing to keep in mind is what Lila touched on about what constitutes an hour worked and the fact that there's no exemption for overtime hours worked. So I think we have to get to a point where those could be salaries, where student athletes could be salaried. And I think there's lots of arguments about what constitutes an hour worked in this context. Brett talked about this a little bit right in the intro in terms of all the time that student athletes spend outside of doing their actually practice and competing, that they'll try to make arguments are hours worked. And that goes to the level of control that we talked about, where the level of control fits and what constitutes an hour worked is going to be a really important analysis to keep in mind. So I do think we could get to that place. I think it would take some legislative fixes, but maybe not as controversial of a legislative fix as just a broad proclamation that they're not employees.
And so thanks for that, Allison. We only have just a couple minutes left. And we talked about a ton of stuff in advance of this presentation. I know people still have lots of questions. I do just want to know, and I'm going to turn back to you, Allison, and Rob, you may have a point to offer as well. But if you think about the self-audits that you were talking about, because we always want to prevent before we have to face an attack. Do you think that there's actually a risk of a ripple effect if we're looking at the student athletes? Suddenly, do we have to start worrying about treating the band members as if they're employees? What do you think about that?
Yeah, so I'll share my view. Rob and I disagree on this, but I will share my view on this. Fundamentally, I think they differ from that. Student athletes differ from everybody else on campus for two reasons. First, I think they're not student run. Student athletics is organized and run by athletic departments with staff and professionals, at least at many institutions, dedicated to organizing and managing them. Plaintiffs' counsel in Johnson sort of simplifies this to outside coaches, but it's not that simple. But I do think it's a differentiating factor. But the bigger one, at least in my mind, is that they're subject to the rules and regulations of outside agencies. And in my view, there's something here that's important. And I think we'll see more and more courts relying on this as they work their way through these issues of who might be the employing entities in this circumstances. It's what Dawson looked at in particular. And there's a lot of cases under the FLSA that talk and exempt from employer status regulatory bodies. We see it a lot in the taxi cab industry in particular. But the idea that there's regulatory bodies that govern the industry, I think that makes the whole industry of student athletics different. Not the concept of amateurism. I know what Justice Kavanaugh said about that, but the idea of the regulatory nature of it and the regulated nature of it, which isn't going away, that to me makes this different.
Last 60 seconds, Rob. Counterpoint.
So the fundamental problem with the athletics is different argument is many universities legitimately view athletics as and any other campus activity as part of the overall educational experience. The problem I think is if we start trying to apply some employment model, some statute that never had college athletics in mind, and it turns everything into something transactional. And I think about, we've talked about like the chess club and debate and things like that. Those are all activities that students do. The university provides economic support. Maybe they get some t-shirts, they cover travel costs. And if you think about the way the RD thought about the Dartmouth case, if that's compensation, then any structure that may come from whatever organization runs the various debate clubs, that's a structure that's outside the university. If they get t-shirts, that sounds like the rudimentary compensation. And so the problem is you're turning all of these extracurricular activities, which are just part of the overall college experience, into something that they were never intended to be, which is, quote, work for compensation under the employment statutes. And I'm not challenging the notion that student athletes put a tremendous amount of time and energy into their athletic endeavors. But that's the same is true for students who are dedicated to particular clubs or other activities on campus. And that's fundamentally what I have an objection to.
I think
So
both
true.
those arguments are true.
So true lightning rod topic to discuss. We could have gone on for hours, probably more. Thank you all for attending. Thank you, panelists. Have a wonderful day.
Thanks, everyone.